Hello, everyone, and welcome to Immigration and Jobs Talk Show. And before we start off with today's program, I wanted to give out this very important disclaimer, and that is displayed on the screen already. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. So, use of information is at your own risk. Friends out there, welcome once again, everyone, to Immigration and Jobs Talk Show. I'm your host, Nipasa Pradhan, and I'm going to be with you for the next hour. And I'm really very thrilled to have you all with us today. And, we are streaming live on YouTube, LinkedIn, Facebook, and Twitter. If you have any questions, please feel free to get in touch with us in this session. And don't forget to tell us also where have you joined us from? And of course, if you have any questions. So, yes, without further ado, we have a very special guest joining us today and someone whose dedication to immigration law and advocacy is truly inspiring. So, please join me in welcoming Ingrid Perez, ESQ, managing attorney and a passionate advocate for immigrants' rights. And help me welcome her for the first time on the show. Hello, Ingrid, and welcome to Immigration and Jobs Talk Show. Good to have you here today.
Thank you so much. It's great to be here.
How are you doing? And would you like to tell us a little bit about yourself and your immigration journey as well in law?
Sure, absolutely. Well, thank you so much for asking. I'm doing really well, very busy with my practice. So, a little bit about me. I'm an immigrant myself. I was born in Brazil and I came to the United States when I was about 9 years old, turning 10 years old. And I understand this journey very well. I came with my mother, my younger brother, and we went through all the struggles that immigrants usually go through: language barriers, cultural barriers, financial hardships, all of that I went through. Um, Eventually, we were able to become permanent residents, get our citizenship, and I went to school to become a teacher. Eventually, I went to law school, where I went to law school in New York at Fordham University, and I've been practicing as an attorney since 2014, and now I practice exclusively immigration law. And my office is in Orlando, but I actually have clients, Orlando, Florida, but I have clients all over the United States and really all over the world. So it's really great to work with all these different peoples of different demographics, different nationalities, and they all bring something special to the United States. And it's just really great to work with these people and get to know them and their work and how it is so important to the United States.
Thank you so much. Welcome to the show, Ingrid. And absolutely, friends, it's going to be a little different journey than usual, I think, because having personally navigated herself in the immigration process, it's going to be really overwhelming and insightful having, answers from Ingrid, expert advisors as well, and all through experience. So, Ingrid, are you ready for today's show with us, this webinar?
Yeah, let's get right to it.
Absolutely. And friends, today's topic is, are you ready to work in the United States? And, in this episode, we will explore EB-1 and EB-2 NIW visas with none other than immigration attorney Ingrid Perez. So, Ingrid, if you could just give a sneak peek into what folks out there can expect today from us in this episode.
Sure. So I think discussing the EB-1A and the EB-2 national interest waiver is really important. There are distinct differences between the two options, but they do eventually lead to the same result, which is a green card, permanent residency in the United States through employment. The eligibility requirements for each are very different. The way that immigration adjudicates these cases have similarities. The analysis that the immigration officer does to adjudicate these cases is important to consider as well, especially as people are planning to submit either an EB-1A petition or an EB-2 NIW petition. Is very important. It's also really important to consider the backlog of these types of petitions so that a person can plan their immigration journey appropriately and make sure that eventually when they are ready to receive that green card based on the approved petition, they're not going to run into any problems. So that is, I think, an overview of what we're going to be talking about and the different ways to get there, what immigration needs, and some general tips for people who want to pursue these petitions.
For sure, for sure. And would you like to also tell us a little bit about IBP, your office?
Absolutely. So I've been a solo practitioner for quite a while now. I actually started in 2019 or 2018 with a colleague. We went our separate ways at the end of 2022, and since the beginning of 2023, I've been on my own. We've been able to grow a lot since then. Right now, I have employees that work with me, and we're focusing mostly on employment-based immigration. We also do some family-based immigration, and we really enjoy working on these employment-based cases, and it's really becoming a niche, which is really, really nice. And in my office, I speak English, Portuguese, Spanish. We have an attorney that works with us that also speaks French Creole to help that population. So it's really great to grow and be able to help more people.
So nice. And how many languages do you speak?
I speak three. So English, Portuguese. Portuguese is my native language.
Mhm.
Spanish, I tell my clients that, we can get by in Spanish. It's not perfect, but I understand them. They understand me. As long as I speak English really well, that's what matters for the purpose of U.S. immigration. So
Yes.
we get by with Spanish. But we also have Spanish-speaking employees in the office. So whenever we need help with the interpretation, we always have somebody on hand.
Very nice, very nice. So very comfortable in communicating in many languages. Friends, you should definitely check out IBP and of course Ingrid Perez. And so Ingrid, let's dive into today's topic. And I got this first question coming up for you, and that is if you can explain, the process of changing a B1, B2 visa to an NIW visa in the United States. And are there any specific requirements or considerations?
Sure. So I think the first thing to keep in mind is that the B1, B2 is a tourist visa. When you enter the United States with a tourist visa, your intention is to come visit for a short amount of time and then leave the United States. You're not intending to immigrate to the United States. So when you
Right.
file an EB-2 and IW, you're telling the government now that your intention is to immigrate. So that's something that's really important to consider. And of course, right now, the EB2 and IW category is backlogged. So what a lot of people would do, which would probably go against, the typical lawyer's advice, is filing an EB2 and IW concurrently with an I-485, which is the application for the green card when that option was available. But,
Mhm.
I caution people against that. I'm very careful with that, I wouldn't recommend that to people. Because again, if that petition is denied, it's never guaranteed your green card application will also be denied, and you would have been here in the United States for quite some time waiting for that approval or that decision. And, now you have to kind of go back to square one and figure out again how coming to the United States. So in theory, yes, you can go from B2, B1, B2 visa to an EB2 NIW, but there's very careful, a person needs to really consider this option very carefully and speak to an attorney before making that change.
Okay. So every case is different, friends. It's always good to have an expert advice, and even better if you have the expert themselves dealing with your case. So always advisable to consult an attorney. All right. So Ingrid, also let's move on maybe to the next question, which I wanted you to highlight, and that is what are the key eligibility criteria for an NIW, and how does it differ from other visa categories?
Yeah, definitely. This is a really good question. For the EB2 classification, right? So we have a classification of the EB2. The minimum barrier to entry into the EB2 classification is having an advanced degree or an equivalent. What that means is an advanced degree means either a master's or a PhD. An equivalent can be a bachelor's plus 5 years of experience. And when I say equivalent, that has to be equivalent to a US degree, right? So there's different ways to meet the minimum eligibility requirement based on a person's education. If a person does not have the educational requirement, you can still qualify for EB2 classification if you have exceptional ability. Exceptional ability means that you have 3 out of the 6 requirements that immigration considers for a person to have exceptional ability. And that would include things like, you have a diploma, a certification for your profession, you have 10 years of experience, you have a high salary, you have recognition, things like that, to be able to make an argument that in lieu of a US diploma or a US equivalent diploma, you have exceptional ability and you meet the eligibility classification. for EB-2. Now, the national interest waiver takes it a step further, right? You're requesting a national interest waiver to do away with the labor certification process that an employer is going to sponsor you for the EB-2. So now you're doing your own EB-2. So in addition to meeting the minimum eligibility requirements, you also have to convince the immigration officer to waive the requirement of the labor certification. And that means having three things, right? Number one is having a proposed endeavor that is in the national interest and that has merit. So these are, what is your work going to be in the United States? How will it benefit the United States as a whole? What strategic benefit is your work bringing to the United States? So that's the first consideration. The second consideration is, are you well positioned to do what you're saying you're going to do? Do you have the degree? Do you have the experience? Do you have a record of success? Do you have people or employers in the United States that are interested in your services? That is the analysis under the second prong of the national interest waiver. And finally, it's an argument that you have to make to immigration, right? That at the end of the day, it makes sense for the immigration authorities to waive the labor certification requirement because your work is urgent, important. Even if there are other American workers available to do your job, it's critical that you're here, and therefore impractical that you go through the labor certification process, and therefore immigration should waive that requirement and grant you an EB-2 national interest waiver. So that is sort of like the lay of the land with EB-2 NIWs. When I talk to people about an EB-2 NIW and I see that they meet the minimum eligibility requirement, we really talk about the national interest waiver portion of it. What are you going to do in the United States? What are your plans? What have you done? And what evidence do you have to corroborate that this is going to be your work in the United States? And of course, to answer the second part of the question, how does this differ from other visa categories? Well, the EB-2 national interest waiver, the way that I like to explain it to people is that it's very forward-looking. It's looking to the work that you're coming to do in the United States and why it is important. The other visa categories for employment-based visas also have a forward-looking component to it, right? You have to you're coming to the United States with intent to continue working in that position. That is, your future intent. But the national interest waiver focuses very much on that in addition to the benefit that you're going to bring to the United States.
Very interesting. Thank you so much for highlighting that for us, enlightening us, and making it so much clearer. I'm sure folks out there who are watching us will agree with me because this is good. Thank you so much, Ingrid. And
You're
I'll
welcome.
take this opportunity, to just greet our audience out there who are dropping in their questions already. So, hi to Messi, Ashik, Neha, Santosh Kumar, a big hello to all you folks, and Meet K. We will take up your questions. Please stay with us, all right? Ingrid is here. And Ingrid, let's quickly move on to the next question so that we can take up our audience questions very soon today in the show. So, if you can compare and contrast the EB-1A and EB-2 NIW visas, particularly for STEM professionals, what factors should applicants consider when choosing between the two? What would you suggest?
This is a question that we can have a whole other segment talking about. So, all right. So I think the first thing to consider is I'll start with the EB-2 NIW for STEM professionals specifically, because there have been some recent updates on the policy manual and immigration policy that explains how a STEM professional can qualify for EB-2 classification. I actually love working with STEM professionals because I feel like they're coming to the United States to solve problems. And for me, at least in my mind, I think that it's much easier to explain a person's endeavor if you look at it through those lenses. And of course, for the EB-2 NIW, you don't need to have the level of achievement that you do for an EB-1A. For the EB-2 NIW, you don't need to show that you are the best of the best necessarily. You can in certain circumstances, and you want to. But there are EB-2 NIW cases for STEM professionals that are approved even though a person does not have citations or publications or different things that would make a person stand out. Because again, it's much more focused on the work you are coming to do in the United States and whether or not that is in the national interest. For the EB-1A, for example, it's a different analysis, right? EB-1A is looking for to see whether you are a person of extraordinary ability, whether you are the creme de la creme, the top 1%, however you want to explain it. So for STEM professionals in the EB-1A category, you still have to make sure that you meet the category in its entirety because it's a two-step analysis for each criteria of the EB-1 classification. So for example, the membership, which is one that is very straightforward for the EB-1A and I think is useful to highlight in this example. For membership, you have to show that number one, you are a member of an association, and that number two, that association requires outstanding achievements by their members as judged by experts. So you have to make sure as a STEM professional that if you're going to argue the membership criteria for the EB-1A, that not only number one, you are a member, and that as a part of your membership, that a barrier to entry of that membership, experts for that association need to determine that you have made outstanding achievements in your profession. So it all goes back to the specific language of each criteria and whether you can meet sort of both requirements of that one criteria.
Okay. Thank you. Thank you for explaining that. I know it would be very difficult because it's, I think, a subject which would take up a whole day, maybe I mean, an
Oh
hour
yeah,
or two to cover up. So we will definitely discuss on this maybe some other time in
yeah.
more detail and explore more.
But I will say for EB-2 and NIW,
Mhm.
the recent policy changes and the recent clarification by immigration have made it very attractive for STEM professionals to pursue EB-2 and NIWs.
Mhm.
And I'm hearing great stories from attorneys who are colleagues, and submitting these cases, and I'm having success myself. So I think right now is a really great time to pursue these cases if you feel like, you have what it takes, or at least speak to an attorney to sort of discuss what your case would look like and the possibilities of an approval.
Sure, sure. Very, very well said. So, I also wanted to ask another question to you, Ingrid, and that is if, suppose, if I want to file, can I file an EB-2 NIW petition while on a non-immigrant visa, example, an H-1B? And if so, what are the potential risks and benefits of concurrent filing with the green card application?
Yeah, so as an H-1B visa holder, H-1Bs are dual intent. So you can absolutely file an EB-2 NIW petition while you're here on H-1B. The benefit of having an approved petition for an H-1B visa holder is that H-1B now can be extended beyond the 6 years that a person typically gets with an H-1B. So this is very beneficial for example, Indian nationals for
Mhm.
which the visa bulletin is so backlogged. So that is a strategy that for sure many Indian nationals are pursuing. Another great benefit of this is that if you have a priority date locked in through your EB-2 national interest waiver, you can then work on applying for an EB-1A, and you can preserve the priority date for your EB-2 national interest waiver petition. I actually recently did this for an Indian client of mine who came to
Okay.
the United States many years ago on H-1B, and his employer had filed an I-140. It was taking
Mhm.
forever. He had a better professional opportunity outside of the United States, so he left. Years
Mhm.
later, he decided to go for the EB-1A, and we filed the EB-1A. He was approved, and now we are in line for the immigrant visa because he had a priority date from 2016. So, it's great because he's now, he was able to now get his priority date, and now he'll be immigrating to the United States with his wife and child. So there is
Mhm.
definitely benefit for that. As far as potential risks, of concurrent filing with a green card application, well,
Mhm.
unfortunately, you can't concurrently file right now because it's backlogged, so the visas are not immediately available, right? But
Right.
assuming you could concurrently file, you are expressing now, you are telling immigration now that you are going from H-1B to a green card when you file that concurrent green card application. The risk of that is if your petition gets denied, your green card application gets denied, and Some people, for example, will stop working on their H-1B. They won't maintain their H-1B, which can be very detrimental. It's really important to speak to an attorney and make sure that you know the pros and cons, because these cases do take a long time. And if you fail to maintain your H-1B, or if you stop working on your H-1B and then go ahead and you start working on your work permit that you get from the green card application, it could put your status in jeopardy in the future if that petition gets denied.
Mhm. Okay, so pretty risky, and I think it's always best to get expert advice. So, friends, do you need an attorney? I would say yes, you definitely should consult one. All right, so moving on, Ingrid, I still have a set more questions I wanted to ask, and if you can provide tips, on strengthening the EB-2 NIW case to maximize the chances of approval, and are there any common pitfalls, to avoid during the application process? If you could highlight some.
Yeah, actually, that's funny you asked, because yesterday I took a look at a potential new client that sent me a denial. And the reason for the denial, at least the main reason for the denial cited by immigration on their denial letter, was that the petitioner focused too much on the shortage of professionals in his industry. And that is
Mhm.
something that an experienced attorney, or at least an attorney that understands the national interest waiver, should know to avoid. Right? We're not just arguing that there's a shortage of workers in the United States. That is what the perm labor certification process is for. So we really want to focus on the benefit that your endeavor will bring to the United States, not just that there's a shortage of workers in your particular industry. So I think that's pitfall number one. It's very important to avoid. I think also, for a person who is looking to maximize their chances of an approval, working in an area that is in the national interest is really important, or creating a niche for yourself in your particular field. So I'll give you an example. I've actually done quite a few cases for mechanical engineers, right? And mechanical engineers work in all types of industries. I've done 3 cases for elevator engineers, right? And these cases have all had successful outcomes. And the argument for the elevator who's a mechanical engineer, is that our infrastructure is growing. This is a very niche area. We all ride elevators all day long without giving a second thought, right? Without understanding the mechanics of it, the certifications and the inspections that go into creating and installing and maintaining safe elevators. So working in an area of national interest is really good for an EB-2 and NIW. And I would also say that, for those who are considering the EB-2 and NIW, speaking to an attorney to sort of come up with a strategy. Even if the person is not 100% ready right now, speaking to an attorney can help the person create, a strategy for the next year or so, depending on how long they want to work on this, so that you'd have a petition that is more likely to get approved. So these cases are so individualized, and so, so particular, that I think having an advice from an attorney would be very beneficial for that person with their specific set of facts and considerations and different needs.
True, true. And as always, friends, it's always important to be very transparent with your attorneys, and also see that your documents are in place. These always work. And of course, you'll have proper guidance and direction once you consult an attorney. All right. So, Ingrid, let's take up one question from the audience, and then we'll surely take more later. Let's take this one from Ashik on YouTube asking, can self employed individuals apply for EB-1 or EB-2 NIW visas?
Yes, and I've done quite a few of these. For the EB2 NIW category, I have done EB2 NIW petitions that have been successful. So I'll give you 2 examples. I did one for a food manufacturer or food distributor, and he actually
Okay.
manufactured or fabricated, I should say, this gluten-free organic tapioca flour from his country. And it was ethically sourced and very minimally processed. And he was
Wow.
bringing it to the United States, and he was distributing it, and different bakeries were, buying his product. And my argument, right, for the national interest in this specific endeavor was that he was bringing an option to Americans that have gluten intolerance. We all want to eat better, and we have a growing population of Latin American immigrants in the United States that may have gluten intolerance, and this is an option for them. And also, it creates culinary opportunities for the United States. And his case was approved. And also, of course, we also argued job creation and economic movement because it was an entrepreneurial endeavor. So I was able to argue that, and I was successful in that case. Another one that comes to mind is an entrepreneur who has a business in the United States, and what he does is he purchases secondhand machinery, equipment from the government at auction, right? And he fixes these in his warehouse. He has a whole team. He fixes these in his warehouse and he sells it to the secondary market. And for that case, I argued job creation, economic movement, but I also argued circular economy. What he was doing is he was, helping the United States circular economy because these products were coming back into the economy. He was refurbishing them and reselling them to the secondary market and making them available for, businesses and factories that maybe don't have the budget to buy all brand new equipment, right? Or in different scenarios where the supply chain is interrupted, having these secondary options are really is really important for a business. And his case was approved.
Right, right. Very interesting cases. And I would say it'll be different, I think. But what if somebody is probably just doing some handwork, maybe doing some embroidery or doing some artworks like painting? And he or she is totally self-employed, maybe just living on selling artworks. What about people like those? Will they be?
Um, yeah, I think it depends on the case. I maybe embroidery, if this person is, received some recognition or something like that, I think that would be a harder case. For arts, right? There is something to be said about culture and artistic expression. I think, maybe,
Maybe. Right. Yeah.
who knows, maybe. I've heard of attorneys who've done, these cases for tattoo artists, right? If they're doing medical
Hmm.
tattoos, that's
Right.
something. So there is all ranges of cases. There are many areas of work that immigration considers as having merit.
All right, let's just stay hopeful, and I think we should consider and reconsider because there are so many options, and I think an expert can definitely help you. And Ashik, I hope that you got your answer. And if you have more questions, you can directly contact Ingrid. The contact details are on the screen, and you can call her in the number 407-906-0068. And you can even email her at info@ibplaw.com and visit her website, ibplaw.com. I for India, B for Bangladesh, and P for, well, pumpkin,
There you go.
law.com. All right. So, Ingrid, I think we'll just go for a short break if that's fine.
Sure.
All right, folks out there, stay with us. We'll just go for a short break. You stay tuned to Immigration and Jobs Talk Show. Don't forget to like, share, and subscribe. All right, we'll be back in a short while. Consultant seeking a new opportunity? We offer job placement services for U.S. citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H-1B, E-3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408-335-6444 or mail us at nipa@higheritpeople.com or visit our website www.higheritpeople.com. Hello and welcome back, everyone, to Immigration and Jobs Talk Show. This is Nipasa Pradhan, your host, and I hope that you have been enjoying this whole program today. We've already covered the half of it with none other than our special guest, who is Ingrid Perez. So, Ingrid, I hope you are enjoying this discussion today with us. You know, she is also a managing attorney, and definitely, friends, Ingrid brings a wealth of experience and insights to our discussion today. So, Ingrid, I hope you are having a good time and looking forward to even answer a lot of questions which the audience have for us.
Yes, thank you so much.
It's been very interesting, you have been sharing some of your cases, and I like how this whole conversation is going so far. Thank you.
You're welcome. Me too.
Cool. So, Ingrid, maybe you could share with us what steps can an individual take to build a strong profile for an EB2 NIW application, and are there specific qualifications or achievements that immigration authorities, they look for?
Yeah, so I think, the tip that I give people is work on your career, and that will naturally inform the EB2 and IW petition. So, do things that are natural for your career projection to show that you are, a member of the profession that stands out. So, for example, if you can join an association and become an active member of that association, I think that is great for an EB2 NIW, and also just has benefits for your profession as a whole, right? Working in projects that are significant, having a leading role in a project or in an organization is also really great. So seek out those opportunities that not only will benefit you professionally, it will also benefit an EB2 NIW petition. It will look really good on a case, right? And specific qualifications or achievements that immigration authorities look for, I think it depends on the profession. I always tell clients to, again, do what is natural for your profession. So if you are a person that is more of a behind the scenes type of person, like a software engineer, for example, right? What can you do as a software engineer to elevate your profession, right? To elevate your current standing within the organization? Or maybe you can, like I said, I like joining associations because that gives professionals a lot of opportunities to do meaningful work. Perhaps you are able to present at a conference or do peer review or publish research articles. I think all of those are really good for not only your professional career, but it also looks good on a petition.
Okay. Okay. Thank you so much. So it's always good to keep it as clear and as natural. Don't try to adulterate it, or just make it full of flowers just to make it look good. But stay true. I think stay true to yourself and to everything on paper. Right,
Yeah,
Ingrid? All
yeah,
right.
definitely.
Definitely. Yes. So, with this, if you can also provide some insights into the May 2024 USCIS visa bulletin that just came out a few days back, and the trends for employment based categories, particularly for India, and maybe how do these trends impact the EB category final action dates?
Well, if there's one thing that is very frustrating in the world of immigration is the visa bulletin, because we just don't see much movement going on right now
Right.
for employment-based categories, and especially for Indian nationals. So I think the word on the street is that not much movement is going to happen. Perhaps when we have a new fiscal year starting October, we'll see some movement there. Hopefully, it will not be retrogression. I do know that immigration is claiming to do as much as they can to use up all the visas for the employment-based categories, but there's still a lot of work to be done, especially for Indian nationals that are so backlogged in the EB-2 category. And unfortunately, it's just a reality that we live in right now. And I think that for those nationals in particular, it's really important to have a clear vision of the future, their immigration options, and start thinking about these things very early on. Once they get an H-1B, we'll wait and see what happens in October. I'm hopeful. I want to stay hopeful, but we'll see, right? We'll see.
Yes, it's always good to stay hopeful, stay positive, and look for options. Don't let your hopes die just because one thing is not working out for you. And like I said, always good to consult an attorney because they will guide you through the best options for you. All right. So,
Absolutely.
yeah, Ingrid, I think we should take up one more question from the audience, and that should be let's take up this one from LinkedIn, which is there, um, which is about boot camps in networking and cybersecurity. Okay, that'll be next. But let's take this one first. Ihab on LinkedIn is asking, are you RTW program with the Workforce Solutions?
I'm not sure I understand that question. Okay, so there's a second
Okay, there
part.
is a follow-up. So I finished two boot camps in networking and cybersecurity, each for 6 months. Is that something that can help, or I have to get a master's degree? I can't get a job in cybersecurity without a green card.
So I'm not sure what the boot camps in networking and cybersecurity lead to. Does it lead to a certification for your profession? If it leads to a specific certification, then perhaps you can argue that you have exceptional ability if you cannot get a master's degree, right? Because I think, as I said earlier, for the EB-2 classification, you can meet the minimum eligibility requirements through an education, like a diploma, right? Master's degree, an
Mhm.
advanced degree, or a bachelor's with plus 5 years of experience that it's equivalent to an advanced degree, or you can argue that you have exceptional ability. So I guess it just depends on what the networking and cybersecurity boot camps lead to. If it's just more like a training, we'd have to just analyze it together with the other types of evidence that this person may able to have to argue that he or she meets the EB-2 classification through exceptional ability.
Right, right. So, Ihab, I think if you need to, you might as well contact Ingrid Perez directly, and her details will keep showing on the screen so you note them down. And quickly, there it's already scrolling, so take them down. And Ingrid, I want to take some more questions actually from the audience, and let's take this one up from Santosh on YouTube asking, I have an I-140 approved on H-1B visa. I am planning to go to India and come back after 1 year, hoping that I can file through EB-1. For EB-1, should I work for the same employer in India and USA? And there's a follow up asking, if I work for a different employer in India and come back to the USA through different consultancy or employer, will I still be eligible for EB-1?
So this is a very tricky question that I think
Mhm.
requires really consultation with an attorney. I definitely would not want to give any tips or advice that a person could rely on here, especially
Right.
when considering changing employers. So my advice to this person is speak to your attorney or
Mhm.
contact me. I'd be happy to speak to you because it's a very specific questions that it's a very specific question, and depending on what this person ends up doing, can have implications for their petitions and eventual green card in the future.
True, true. So Santosh will, attorneys will definitely need more information about your case, and it would be best to consult with your attorney or even Ingrid for that matter. Her details are on the screen. Please contact her. All right, so let's take up another one. This one is from Meet. Meet is asking, I am on L1 and my US employer here is filing my EB-2, but I have been told that the perm certificates is going to take 400 plus days now, and then I-140 will be submitted. Is it true that that perk now takes? Um, there's a follow
400
up asking.
days.
I think it should be perm. Yes.
Yeah.
Is it true that perm now takes 400 plus days? Secondly, can the L1 get renewed automatically after uh, approval of I-140 beyond maximum extension of current L1, which is 7 years, 3 plus 2 plus 2. Okay, that's very, very
Okay.
specific.
So yeah. So I'll try to answer this question as best as I can. So the first part is the perm taking 400 plus days. Yes, the perm process is taking a considerable amount of time. I had a perm that I filed last February, and
Mhm.
it was just certified in March of this year. So it's taking quite a long time. That is just for the
Mm.
certification alone. This doesn't include necessarily the prevailing wage determination and the recruitment process. So It could easily go to 400 days. As far as can the L1 get renewed automatically after an approved I-140, I believe the answer is no. For you to have an L1 extension, you need to submit that request to immigration through an I-129. It's a different petition. The L1 is dual intent though, but to have it extended, you need to make that request to immigration. It's not going to happen automatically.
Mhm. Okay, thank you for taking that up for Meet, and I hope that Meet is happy with the answer. If you have more questions, Meet, we are still here for a little more time. You can drop in your questions again. All right, so let's move on to this next question. And this is from Chiranjeet asking, how does USCIS evaluate whether an individual's work is in the national interest for an EB-2 NIW visa? Can someone apply for both EB-1, EB-2, and NIW visas simultaneously?
So this is a really good question because it sort of informs when I have consultations with clients. We talk about how the person's work is in a national interest. So the way that immigration review looks at this, right? They want to, number one, see what is your specific endeavor. Not just that, for example, you're coming to work in the United States as an engineer, but what specifically are you going to do as an engineer? Are you going to work, on elevator installations like my previous clients, or are you coming to work, in defense, engineering for antennas or something like that, right? And if you're coming to the United States to do that type of work, why is your work important, right? So, in an example of a mechanical engineer who's maybe working on, these defense tools or defense antennas. I actually have a client right now working on this specific endeavor, right? It's important because the United States uses these technologies in our defense, right? So this work is very important to the United States. So having people here who are working on these technologies to help the United States maintain its defense capabilities are really important, right? So ask yourself why. Why is this work important to the United States? Is it supporting a critical sector, right? Is your work supporting a manufacturing sector or, the financial sector or the health sector, right? What specific problem are you coming here to solve? So immigration is going to look at whether there is a need for your services, right? For example, we all know about the bipartisan infrastructure bill, right? It has been, you can use that a lot to argue that if you're coming to the United States to work on an infrastructure project, right, that is of national importance because the government has already passed the law. It has all these investments being made in our infrastructure and building infrastructure to our crumbling bridges and our roads is all very important. So you can definitely argue that. Another thing that immigration can look at is, for example, if you're helping to advance an important if you're coming to the United States to help advance your industry. So maybe you are working on, something in our healthcare system that is maybe seeking a cure for a particular disease, or maybe you're doing important research that will inform stakeholders, things like that, right? So that is what immigration is looking for. I like to think of it as what problem are you coming to solve, and is that problem important enough for the United States to warrant you coming to the United States and working in that specific problem? That's how I like to explain it to people. So I think that kind of summarizes it, right? And can someone apply for both an EB-1 and an EB-2 NIW visas? In this case, I think what this person means to say is the petition, right, simultaneously. The answer is yes. You can have multiple petitions going on at the same time, and then you decide, hopefully both of them approve, and now you're just waiting for the visa bulletin to become current. Or, if one of them does not get approved and the other one does, at least you'll have one approved petition. But yes, you can file two petitions at the same time. I've also had clients who had I-140 petitions through their employers, and then they got married to a U.S. citizen. So then we did a U.S. citizen petition. That is possible. You just then have to choose which way you're going to get your green card.
Yes, I think that's the goal and always the focus, right, Ingrid? So I hope that answer was very, very sufficient for Charanjit as well. And if you have any further questions, we are still here for some time. Let's move ahead to another question. There are so much. I don't know if we can delve into our questions again, but let's take this one up. This is actually from one of our WhatsApp members asking, I recently came to know about the GS 2210 Information Technology Management Series, and that the US government is waiving college degrees to higher IT skilled individuals. Do you have any thoughts?
I'm actually not familiar with that. I want to look
Okay.
into it a little bit more, but I don't know if this has, I don't know how this would impact immigration because I haven't seen anything like that. But I guess the United States can always waive this requirement, right? If a person is a U.S. citizen or has work authorization. But I don't know how this changes much immigration because for immigration, the criteria is very clear.
Okay. Okay. Thank you for taking that up. And um, let's go on to this next question I have, and that is, what do you consider? But before that, Prashant S is asking, I have an expired H-1B and I have never used it. How do I renew it?
This is a tricky question. I think that, it would be really important for this person to speak to an attorney. But generally, if you have some unused H-1B time, you can recapture it. So I think it would be very good for this person to seek an attorney, to see how they can do that. I think that's what they're asking. If they've never used their H-1B time, can you get it back? The general answer is yes. Work with an attorney, work with your employer, and maybe you can make that happen.
Okay. Thank you for taking that up, and I hope it was pretty clear. Now, let's move on to this next question, and that is also from another WhatsApp user asking, I recently, sorry, what do you consider your greatest success story or most rewarding case, and what made it stand out to you? How do you stay current with the constantly evolving landscape of immigration law and policy? This is directly to you, Ingrid. So
Oh,
please
this
share your story.
Well, I mean, whenever I have an EB-2 or an EB-1 approved, it's always, a success story because these cases are discretionary. But the one that is very near and dear to my heart is the one that I spoke about earlier for my client who's an entrepreneur working with refurbishing these machines for the secondary market. And the reason why that case is really important because just a bit of a backstory. I actually spoke to the client's wife for the first time, and I didn't want to take the case. I thought it was going to be a difficult case. I wasn't sure if I could get it approved, and I wasn't really convinced. So then we had two meetings. The first meeting was with my client's wife. The second meeting was with my client's wife and her husband, who was the owner of the company. And we started talking more about, their business, their career projection, and I came to find out that about 15 years ago he was working at a gas station, like filling working at a gas station, like pumping gas into cars, and then he decided to
Mhm.
become an entrepreneur, and he achieved a lot of success in his country,
Nice.
and his story was just incredible. And I said, okay, if you really want to go for it, let's go for it. They did an L1. The L1 was denied, and they were just sort of like at their wits' end, not knowing what to do. And I made it
Mhm.
very clear to them, listen, like, I think it's a 50-50 shot. Let's go for it. As long as you understand that I can't guarantee results because I'm skeptical about taking on the case that I don't feel 100%, on.
Mhm.
I mean, even though I can't guarantee a result ever, even if I feel it's a strong case, but,
Right.
I put myself in the shoes of the client and I understand that they're putting all their hopes and dreams in this. So
Mhm.
I decided to take the case, took the case, and then we filed it, and they insisted on premium process because they just needed to know. And they knew that premium process could lead to an RFE. And I was like, okay, as long as you're aware, we had many back and forth conversations. We filed the
Mhm.
case process and it was approved in 7 days. And I was shocked. I couldn't
Wow.
believe it. I was expecting an RFE. I was expecting some pushback. His case was approved. And I was like, wow, this is really amazing. And
Wow.
it just really made a huge difference for my client and his family, and they're just so happy, and they just they're so grateful, and I think that was very, very, very heartwarming. So it made me
So
feel really, really
nice.
good. And how do I stay current with the constantly evolving landscape of immigration law and policy? I'm constantly reading. I'm constantly looking into different cases. I'm constantly reviewing the policy manual. And also being a member of the American Immigration Lawyers Association is very helpful because we have a huge network of attorneys that, give you tips and advice and sort of like exchange ideas. So that's really good. So
Mhm.
that's how I do it. And I think practicing in this arena, having a constant flow of cases forces me to be constantly updated in this evolving landscape of immigration law and policy because it is sometimes a whirlwind and it's really important to be updated and know about the policy updates, the memos, and all of that because it can really make a difference.
True. So true. So true. And this is Ingrid Perez, friends out there, changing lives and of people changing lives of people out there, one immigration case after another. So stay with us a little more. And we are taking out questions. So let's take a few more. Let's take this one from Raya. Raya is asking, how would you respond to critics who argue that the EB-2 NIW visa program is vulnerable to fraud and abuse, and that it prioritizes foreign workers over equally qualified American citizens? Do you have anything to say to this?
Yeah, so I think, getting an EB-2 NIW approved is extremely difficult. And, I think that if a person is going to get it approved using fraud or abuse, I think immigration will catch on. Whether they catch on to it during the petition stage or whether they catch on to it during the adjustment of status or the immigrant visa application stage, I don't personally think that the EB-2 and IW visa program is vulnerable to fraud and abuse. And it's meant to, bring foreign workers into the United States. And actually, one of the arguments for a national interest waiver is that even if there are qualified American citizen workers, you are not taking away their job. It's not going to affect their job. You are bringing something extra to the United States. You're not taking away from an American worker, right? So that's how I would respond to this. I guess people can have these criticisms, but I think generally, I don't think that it's subject to abuse or fraud. Of course, you as the petitioner on these cases, you must always provide truthful, accurate information to the immigration authorities. I mean, if you choose to use fraud or abuse the system, you do so at your own risk, and I don't think that an ethical attorney would support a person's effort in doing this.
Mhm. Right, right. Thank you so much for taking that up for Raya. And I hope you don't mind staying with us a little while longer. We'll take a few more questions from the audience, if that's fine with you, Ingrid.
Absolutely.
Okay, let's take up Ash. Ash already on screen asking, after my number is being picked up by H-1B lottery, can I change the petitioner?
So you can change employers once you're in the United States with an H-1B. You can change employers. It's just important to be mindful of when you're doing this because you don't want to jeopardize your H-1B. There's some special considerations there, so it's really important to seek legal advice when changing your employer on an H-1B.
Okay, thank you. Thank you for taking that up. And Ash, I hope that is clear for you. Let's take this one from Gavaskar asking, can you share an example of a successful EB-1 or EB-2 NIW application for a client with a non-STEM field background, maybe in arts, humanities, social sciences? And there is a follow-up asking, and how did you effectively demonstrate their extraordinary ability or national interest to overcome the additional scrutiny and skepticism often applied to such cases?
So the one that comes to mind is the one that I spoke about earlier for my client who's an entrepreneur in the food fabrication and distribution. He was a very, his endeavor was an entrepreneurial endeavor. So I submitted a business plan. We showed financial projections. We showed, his break even analysis. We described the market, the industry, all of that. I do mostly STEM professionals with EB2s. I did one that I guess is STEM, but maybe also has something to do with a non-STEM profession, and this was for, if I remember correctly, she was a pathologist, but she worked more in as a physical therapist, even though all of that is STEM related. But her work was in ergonometry. She made sure that institutions and her clients had ergonomic accommodations for their employees to make sure that they were working in a good environment, that their health was being, prioritized, that their well-being and all of that. So she had this consultancy business and she did exactly just that. And for her, we submitted a professional plan. She was going to work for herself. She did decide to invest in a professional plan that sort of explained the services that she was going to offer, her the industry, her potential clients and things like that. And another thing that I always encourage people to do is work on your connections in the United States. Is there an employer, a client, a partner, a customer that can write a letter on your behalf to sort of like affirm that they're interested in your services or that your services are needed? I think that's also really good for a petition.
Thank you. Thank you for taking that up for Gavaskar. And before we wrap up our show for today, Ingrid, I just wanted you to take up another question for us, and that is, with over 1.2 million individuals waiting for green cards, particularly in the EB-1, EB-2, EB-3 categories. What are the implications for applicants, and how does this backlog affect visa processing times and priority dates as well?
Yeah, this is a great question. It's a difficult situation to be in, and I'm definitely sympathetic to people in this situation.
Yeah.
I think it's really important to explore all options. Obviously with the guidance of an attorney to make sure that you are not sort of hurting yourself in the process, right?
Mhm.
Um, that's very important. For the 1.2 million people waiting for green cards, I mean, unfortunately, the reality of the situation is unless the law changes and we are able to, improve this backlog and improve the waiting times, it's just something that we're going to have to deal with. I mean, there has been some very incremental progress, but not enough, not nearly enough that's needed. And I think that, what needs to happen is a change in the immigration laws, utilizing the H-1B to its maximum capacity, ensuring that the visa bulletin, or that the quotas for immigrant visas per category and country caps and things like that, are addressed, because that is something that, creates a lot of backlog. Obviously COVID caused a huge problem around the world for people waiting for immigrant visa appointments at abroad, but also the backlogs here in the United States. And maybe, not maybe this isn't something that adds to the backlog, because this may be something small, but there, or a small percentage of people in this particular situation. But I have seen situations where a person will have an approved I-140, but they have a denied I-45 because they didn't approach the immigration process correctly, right? They failed to maintain their
Right.
status, or they took a shortcut. So, you have this approved I-140 and you're very happy about it, but you realize that you're not going to be able to get a green card, at least through, an adjustment of status application here in the United States, because you failed to maintain your status. So maintaining your status is really, really important if you're here in the United States, regardless of the backlogs. It's very important to keep that in mind, because you don't want to jeopardize your case in the future. The ultimate goal is that green card, and you have to make sure that you walk a very straight and fine narrow line to make sure that happens in the future.
So true, so well said. And I think what I can say is one episode or one webinar was just not enough. An hour was not enough to discuss and explore everything about EB-1, EB-2 visa categories. So Ingrid, I think I would just request, maybe if you could come back and we could discuss more, maybe in another
Yeah,
webinar, it would be great.
I'd be happy to.
Oh, that would be so great. Thank you so much. It was such an honor and a pleasure to have you here with us on Immigration and Jobs Talk Show with us here, Ingrid. I hope you had a good time today discussing and exploring today's topic.
Yes, I had a wonderful time. Thank you so much for having me.
Thank you, Ingrid. Have a great day ahead, and I hope to see you soon again then.
Likewise.
All
Bye.
right, friends. Bye bye. Ingrid Perez, friends, managing attorney and a passionate advocate for immigrants' rights. So I hope that you connect with her and check her out. Of course, if you have questions to her directly, also contact her. And yes, her details are on the screen. 407-908-0068 is where you can give her a call. And you can even email her at info@ibplaw.com, and also visit her website, ibplaw.com. Once again, I repeat the number: 407-906-0068 is her number. And thank you once again, Ingrid. I'll see you soon.
Thank you.
Thank you, all you viewers out there, for joining us in today's session. And if you have any further questions, don't forget to drop them in the comments below. We'll be happy to take them and even forward them to Ingrid. And like I said, you can also contact Ingrid and contact me as well. You can call me in the number 408-335-6444, or email me at nipa@higheritpeople.com. Or, yes, definitely don't forget to visit us at www.higheritpeople.com. And thank you so much once again for joining us. I hope you all have a great day. Stay with us and don't forget to subscribe and hit the bell icon so that, whenever we have latest updates or discussions like these and interesting and intriguing webinars that would be very beneficial to all you immigration, all you folks out there who are very interested to get to know better and be updated about immigration, this is your perfect stop. So Immigration and Jobs Talk Show, that is our handle. And yes, subscribe to us. Bye-bye for now. This is Nipasa signing off from Immigration and Jobs Talk Show. Consultant seeking a new opportunity? We offer job placement services for U.S. citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H-1B, E-3, TN, and green cards. 20 plus years of experience in the industry, exceptional employee benefits, highly rated by our employees, global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408-335-6444, or mail us at nipa@higheritpeople.com, or visit our website www.higheritpeople.com.